Okay, it is a little bit after 6:30, 6:31. Welcome to the final lecture for Constitutional Law J331. I will spend some time going over the details of the assignments for this week and remind you that next week is the final week and that all assignments are due in by Friday, the 15th of December. All assignments are due by Friday, the 15th of December. After the 15th of December, no assignments will be accepted. Okay, so I'm going to get right into sharing my screen, and this is what I want you to see. Here we go. So, reminder to check your rubrics for your assignments. And then we didn't have a lecture week 8. That was Thanksgiving. So now we're doing the final one for week 10. Here is the announcement. We're going to discuss punishment, bail, and fines, Chapter 13 of Constitutional Law. Your discussion post is, your initial post was due last night, Tuesday night, 11:59 p.m. Central Standard Time, cash for cars. Your reply post is due Saturday at 11:59 p.m. Central Standard Time. And then your written assignment, the death penalty, satisfying all the requirements that I'll be discussing in a minute. Make sure you have citations and references and a cover sheet as well. Okay, so hope that you will be finishing strong. So let's take a look at the course calendar. Course calendar is right here. And so this is where we are this week, going over the assignments that I just gave you, reminding you that next week, the week you have your initial posts that are due Tuesday, but your reply post and your written assignment is due on the last day of the quarter, which is the 15th. So you want to make sure you complete that. So let's take a look at week 10. Again, repeating your assignments, your discussion posts, and then your written assignment, a 1 to 2 page document with citations and references, APA formulated, and a cover sheet as well. Okay. So now let's go back to the lesson content for the week. And we look at and we see about punishment, bail, and fines. And so here's some material that you need to make sure that you read the overview. I'm not going to go over that for you, the objectives. And then these, again, are the assignments for that. Okay? So make sure that you take a reading of this. And then while I'm at it, might as well take a look at week 11. And again, tell you what the assignments are for the final week. Your discussion post, initial post will be due on next Tuesday night, 11:59 p.m. Central Standard Time. And then your reply post will be due on the last night. So in week 11, you have the final exam. Make sure that you understand there is no time limit. However, you only get to submit your answers once. You should not have your book open at the time, and you should be able to complete the answers to the questions, the ones that are fill in the blank, or either write some information. I'm going to read those detailed. So You want to make sure that you do that, and that's going to be due by the 15th. Exactly. Okay. So now let's go into uh, the lecture for today, chapter 13. Chapter 13 is the remaining amendments and a return to the Constitution. So, as you already know, the Constitution is a very important document, and that the Constitution is interpreted by cases, continued research and changes, and the amendments that we've covered so far have been the most popular ones, but there are four remaining of the Bill of Rights: the 3rd, the 7th, the 9th, and the 10th, that we'll be briefly covering this chapter. You don't hear a lot about these, but we're going to go ahead and we're going to talk about them for the next 35, 40 minutes. The 3rd Amendment of the Bill of Rights prohibits housing soldiers in private homes during peacetime without the owner's consent and during wartime. And so the courts haven't had any reason to review this because it's more historical. And as it says, it's the idea that government is to not bother people and let people alone. So soldiers could not take over private homes during peace times. We don't have that as an issue, so it's just an amendment for historical purposes, and that's why you don't hear very much about it. And then the 7th Amendment. The 7th Amendment establishes the right to a federal jury trial for all suits that are more than $20, and extends the right to a jury trial to civil proceedings. And so this particular amendment, right to a jury trial, is based on whether the suit involved legal issues similar to issues raised in cases for which federal jury trials were granted by common law. But once again, statutory issues have taken over that, and you don't hear very much about the 7th Amendment. So you really don't have to worry about that. The reason for these, the 3rd and the 7th, is so that you will be aware. It says, why don't they tell us about these or have some discussion about them? It's because there's not really been any legal issues relating to these particular amendments since the Constitution. The 9th Amendment sets the right of the citizens to extend beyond those listed in the Constitution, and it's a historical amendment as well. It says rights not enumerated, specifically listed in the Bill of Rights, were known as unenumerated rights, such as the right to privacy, right to interstate and international travel, right to vote, and freedom of association. These are basic tenets that we have here that flowed out of that. The right to privacy has been referred to by the Supreme Court and has not been used to infer such a right, but the 9th Amendment does not guarantee this right. So the point of the matter is generally you'll hear this in conjunction with the 4th Amendment, unreasonable search and seizures. But again, this is a historical amendment. And then the final one, let's deal with Griswold. In terms of the privacy aspects, where there was a contraceptive case, and the question is, does the Constitution protect the right of marital privacy against the state stepping in and requiring that individuals not use contraceptives? And the answer is yes, the Constitution does. Considered to be the first case in which the Supreme Court addressed the 9th Amendment, which shows a belief of the Constitution's authors that fundamental rights exist that are not expressly enumerated in the first 8 amendments and are not the intent of that list and not to be exhaustive. There are certain zones of privacy in which the government may not intrude. Basically, the concept and idea is that a person who is an adult, consenting adult, should have the right to uh, privacy, and the government should leave them alone, and particularly dealing with sexual issues. And that's why we have in the law sodomy as legal as long as it's consensual, these kinds of things. So the bottom line is that this case just basically touched on the Ninth Amendment, and it's one of the few cases that you'll hear relating to the Ninth Amendment. Then finally, the 10th Amendment. The 10th Amendment deals with federalism. Federalism is a principle that's shared by the national government and the states. And so therefore, the powers that are not delegated to the United States by the Constitution nor prohibited by the states are reserved to the states or to the people, and seeks to ensure to all people that the federal government will not get too powerful. Basically, this comes into play when the federal government seems to be reaching into or interfering what we refer to often in constitutional terms as states' rights. And you'll see here that powers of the national government that are listed or implied by legal authority are delegated to the states. And so the national or federal government should not interfere. States retain those rights to police what's happened in their boundaries. That's why there are laws that are federal laws. However, though, the federal government defers to the states to implement how they apply those laws. An example here goes back to 1819. Does Congress have the power to incorporate a bank? And does the state of Maryland have the power to tax it? Congress has the power under the Constitution to incorporate a bank, but the state of Maryland does not have the power to tax an institution created by Congress, because this is one of the powers that was established for Congress. Moving further along, in Lopez, the gun control issue made it unlawful for any individual knowingly to possess a firearm at a place that they knew had reasonable cause to believe was the school zone. So this student carried a gun into the high school and was arrested. So the issue was, does this act exceed Congress's authority under the Commerce Clause? So the Supreme Court struck down the act, and the reason is the possession of a gun in a local school zone is in no sense an economic activity that might, through repetition elsewhere, have a substantial effect on interstate commerce. In other words, basically taking hands off and saying it's up to the states to determine how that's going to operate in their jurisdiction. That's basically what they were saying. In Prince versus the United States, the Brady handgun, which requires background checks, the federal law required local chief officers, law enforcement officers, to perform background checks on purchases of guns. So the issue was whether the necessary and proper clause of Article 1 of the Constitution can Congress temporarily require state law enforcement, chief law enforcement officers to regulate purchases by performing those duties under the Brady Bill. The Supreme Court ruled that the federal government was not empowered to require state or local government agencies to run background checks. Again, according to the court, the background check is a separate state sovereignty, once again expressing the fact that it's up to each state to determine the processes that they would have, and that the government would not overreach, again, relating to the 10th Amendment of the Constitution. So additional amendments have come and gone, proof that the Constitution possesses the ability to respond to America's needs. The 11th Amendment, we don't even hear that. This amendment is the only one that deals with the judicial power of the federal government. It's actually more an administrative thing. It was introduced the day after the High Court ruled that a citizen of one state had the right to sue another. But we don't even deal with that anymore. Just a little historical thing. The Dred Scott case, which is a very interesting case that I'm very familiar with through my constitutional law classes in college and then in law school, where this person, Dred Scott, was a slave in Missouri. And for about 10 years, he lived in Illinois, which Illinois is a free state, and in an area of the Louisiana Territory where there was no slavery and was forbidden because of the Missouri Compromise of 1820. So after he returned to Missouri, he sued unsuccessfully in the Missouri courts for his freedom, claiming that his residence in the free territory made him a free man. So the issue was Dred Scott free or a slave in the state of Missouri? The holding was that he was a slave. Under Article 3, Section 4, Article 3 and 4, the Constitution, the court ruled that no one but a citizen of the United States could be a citizen of a particular state, and that only Congress could confer national citizenship. Taney reached the conclusion that no person descended from an American slave had ever been a citizen for Article 3 purposes, and that decision is moot now. It doesn't mean anything, but is a historical case. Amendments beyond the Bill of Rights, which the 13th Amendment abolished slavery. So it basically did away with Dred Scott. And so the 13th Amendment freed slaves. And so this hardly ever happens, that amendment to overturn a specific Supreme Court case. And the reason why it is because the processes that you have to go through to add an amendment to the Constitution. But it's one of the few times. And so the 13th Amendment basically did away with the previous decisions I discussed, Dred Scott. Came after the Civil War. The 14th Amendment, due process and equal protection of the law. The Supreme Court has chosen through many cases to apply certain amendments to both federal and state governments through selective incorporation. In other words, the provision of the Bill of Rights are applied to the states through the due process clause. So therefore, the 14th Amendment made it possible to take the federal law and then say at the federal level it applied, but then at the state level there needed to be a mechanism. And so the 14th Amendment came forth and implemented the 14th Amendment to the Due Process and Equal Protection Clause to each and every single state, so that it applied, and that was what it did. So if you're confused, all it really said was, once upon a time, the 14th Amendment, originally as created, was not intended for the states. So if you're dealing with a state issue, then it didn't apply until the 14th Amendment came about. Then the 14th Amendment extended the federal due process and equal protection clause to the states. Not all amendments and other portions of the Constitution deal directly with specific rights and liberties. 7 amendments deal with the numerous matters related to how the federal government is to be structured and its officials elected, such as the House and the Senate, the courts, and things of that nature. So it's more administrative than anything else. The 12th Amendment established the electoral system, or the Electoral College, which at today's time is under severe attack because of the way that it's being used to elect presidents. The 14th Amendment established how representatives are apportioned and what their qualifications are. So representatives of the House. And then the 17th describes how the Senate is to be composed. Right now it's 50, it's 100, 2 for each state, what the qualifications are and how vacancies are to be filled. I remember this extremely well Bush versus Gore, where this had to do with the election issue. The Florida Supreme Court ordered hand counting of some contested ballots in a Miami-Dade county during the presidential election. Then the governor was Bush, and he requested a stay of the Florida Supreme Court decision. Did the Florida Supreme Court, violate Article 2, Section 1, Clause 2 of the U.S. Constitution by making new election law? And the holding was yes. Notice is a 5-4 decision, and whenever you see a 5-4 decision, that can be changed by the change of one particular judge being selected and the cases or similar issues coming back up before the court again. And the reasoning for this is that different standards were applied from ballot to ballot, precinct to precinct, county to county. So the recount was arbitrary and disparate. But the dissent argued the Constitution requires that every vote counted, and the court should defer to Florida's fundamentally right decision. So it was one of the decisions that decided the election, and Al Gore lost because of that. We also refer to it as a hanging chad state. Amendments relating to the election of and structure of Congress. 20th Amendment, established in 1933, established the term of the president and vice president to end at noon on the 20th day of January. That's why a new president is put into office. And the terms of senator and representative end at noon on the 3rd day of January. Senators are elected for 6 years. House of Representatives every 2 years. Also established how Congress meets the chain of succession. So if the president is no longer able to carry out, and it starts with the president, then it goes to the vice president. My recollection is then it goes to the Speaker of the House, and then I lose track from there. But the 20th Amendment actually lays out the basis for the succession of president. The closest that I've ever seen is vice president. We were at one point heading towards Speaker of the House, but we never quite made it there. The 22nd Amendment restricted the term of president to 2 terms, which means that the President of the United States can only run for 2 terms, and you all know that. Even if someone says that they sit out and then try to run again, you can't. 2 terms means 2 terms. The 23rd representative gave the representation to the district that constitutes the seat of government. So added representation to Congress for the District of Columbia. Prior to that, they did not have any at all. The 25th Amendment established procedures for filling vacancies for action to take place should the president be unable to discharge the powers and duties of the office. We've kind of talked about that already. This may come into effect again soon. We don't know. The 27th Amendment is to prevent Congress from setting its own salary because of the apparent conflict of interest, obviously. And Congress has continued to give itself cost of living raise, which has not been considered the same as an actual raise, which kind of, to me, doesn't make sense, but that's what the amendment has said. And you have to remember who's in control of that. The voting rights, the 15th and the 19th Amendment. The 15th Amendment in 1870 required that the right to vote should not be denied on the basis of race or color or previous condition of servitude. In other words, those who were formerly slaves. Black males were also given the right to vote in the 15th Amendment in 1870. 19th Amendment in 1920 required that the right to vote should not be denied to women, basically, or on account of sex. Women get the right to vote 50 years after black males. I don't know why they put that in there, but anyway, it did happen. They exist because of the officials' deliberate indifference. It's amazing when you go back historically and see things. That's why people should make sure they go to vote. The 24th Amendment requires that the right to vote should not be denied because of the failure to pay any kind of poll tax or other tax. This was happening quite frequently to blacks in the South, that you had to pay the tax. You also had to pass tests. Like, for example, they would present to you a jar of beans, and you have to tell them how many beans were in the jar. And if you got it wrong, then you weren't given the right to vote. But the 24th Amendment did away with those kind of things. Notice the year. It was in 64. It was a year after the Civil Rights Act. I mean, well, around the same time, the Civil Rights Act of 1964. But it's amazing that that kind of thing happened. I mean, it just came about in 53 years ago. That shows you the state of this country. 26th Amendment, 1971, did something that didn't exist when I came out of high school, lowered the voting age to 18. We couldn't do it until you were 21 when I came out, but now it's 18 years old, and you can register to vote at that particular time. Taxes. 16th Amendment established the federal income tax, and then so Congress has the power to lay and collect taxes. So it's the 16th Amendment you can blame for April 15th. Prohibition. This was an 18th Amendment, prohibited the sale and purchase of liquor, intoxicating liquors. Enforcement, they said, would seem as hopeless because the people didn't want it. It's kind of like in Chicago, they had a tax on sweetened beverages in Cook County, Illinois, and the people didn't want it. And so taxes were being collected, but the people made it clear that they were not happy with it. And then so many of the people who had voted for it previously on the Cook County Board decided better, and they did away with that effective as of December 1st, just a few days ago. So basically, because people wanted to get to drink and do what they wanted to do, and it was hard to enforce it, you had the mafia and the mob, Al Capone, and people like that dealing with alcohol illegally. And so the 18th Amendment in prohibiting. So in 1933, between 1919 and 1933, the country was dry, but legally dry, repealed the 18th Amendment, and there's no longer been. And so the 21st Amendment is a cutting point in terms of allowing alcohol to be legally sold. Attempts at other amendments. Various amendments have been proposed. Congress has considered the amendments prohibiting the burning of the American flag and amendments establishing victim rights, but haven't really gotten that far. Again, remember I told you that it's not very easy to get an amendment to the Constitution. There's a lot of steps you have to go through. In 2003, the Senate subcommittee approved a proposal to amend the Constitution to guarantee rights to crime victims. Overall, Congress is reluctant, it says, to make significant changes by adding amendments because of the things that I've said. And so these are just a few historical things that, you just kind of share with you as we conclude this quarter, this course, and making sure that you understand what constitutional law is all about. I always tell my students, I say, try to learn as much as you can historically so that you can understand how things are taking place and why things are taking place at the present time. So I am going to terminate this session. I will be sending out an archive sometime tonight or tomorrow. So again, I wish you the best in your future. If you have any questions as we approach week 11, feel free to reach out to me. I do encourage you to, again, look at all the materials that took place between week 6 and week 11 to be prepared for the final exam. And so with that, I'm going to say good night.